The cameras flashed. The crowd froze. And just like that, Hollywood had a new obsession. Selena Gomez accused of fraud in a new legal battle.
Oh, it is such a wild story.
Welcome to Starscope Report. Join Jordan and Jamie as they uncover Hollywood drama, music industry shakeups, and viral influencer scandals. From red carpet surprises to social media controversies, we dive deep into the stories behind the fame.
And today's story is, it's just mind-blowing.
It really is. Because imagine you're a seasoned, institutional investor, right? Your entire career is built on mitigating risk.
Yeah, you play it safe, you check the math.
Exactly. You would never hand over $1 million for a tech product you've never actually seen, based on a business model that hasn't been proven.
To a team that hasn't even written a single line of code.
Right. You would be laughed right out of the boardroom.
Right.
But what if the person pitching you that invisible product has over 500 million Instagram followers?
That changes the math entirely.
And what if her name is Selena Gomez? Today we are looking at how the ultimate cheat code in modern marketing allegedly turned into a massive federal fraud lawsuit. So let's get into it.
The contrast between the public narrative and the legal reality here is just incredibly stark. We are unpacking a 48-page federal legal complaint recently filed in Delaware.
A huge document.
Yeah, and the plaintiffs are two investment entities. So Wondermind SRS 44 LLC and Bespoke Wondermind SPV 1 LLC.
And they are leveling some serious allegations of fraud against Selena Gomez, her mother Mandy Teefey, and their former business partner, Daniela Pearson.
Right, all centering on the collapse of their mental health startup, which was called Wondermind.
So to give you the complete picture, we are pulling from the actual legal complaint alongside in-depth investigative reporting from the Fashion Law, Eastern Herald, Forbes, and a massive expose from The Cut.
Those articles are just, wow, they are heavy hitters.
Yeah, and our mission today isn't just to, read you a timeline of who sued who. We are going to explore the underlying mechanics of venture capital.
Right, the psychology behind it.
Exactly. We want to understand why professional investors will completely abandon standard due diligence when there is a celebrity attached, and, well, what happens when the celebrity founder model is forced to answer questions under oath in federal court.
Which requires looking closely at the initial pitch, because the root of this lawsuit traces back to the spring of 2022, when Wondermind opened its Series A investment round.
Okay, let's unpack this, because if you are listening to this and wondering about the terminology, a Series A round usually implies a company has figured out its basic product, right?
Yeah, they have some traction.
Right, and now they need institutional money to really scale it. You're supposed to be pouring gasoline on a fire that is already burning.
But Wondermind had only launched in late 2021.
Exactly. Yet by spring 2022, they were pitching themselves not just as a startup, but as this revolutionary mental fitness ecosystem.
Yeah, they promised daily newsletters, a slate of podcasts, physical consumer products, and an interactive digital app.
The ambition was towering. And the investors we are focusing on today ultimately put in nearly $1.2 million.
Which is a huge check to write.
But they didn't write that check in a vacuum. The lawsuit argues that the investment was secured based on a highly specific, highly lucrative set of promises.
And the most critical component of that pitch was, of course, the role of Selena Gomez herself.
Right, because the complaint makes it very clear. Gomez was not pitched as just an influencer who would occasionally, post a branded graphic on her Instagram story.
No, she was presented to these investors as a true co-founder.
She held the title of Chief Impact Officer.
The pitch deck essentially positioned her as the head of marketing, who would be intimately involved in the day-to-day building of the brand.
The implication was that she would leverage her massive global reach and her very real, very public reputation for mental health advocacy to guarantee the company's success.
And while Gomez provided the cultural capital, the business credibility was supposed to come from the co-CEO, Daniela Pearson. Right, because in the venture capital world, past performance is heavily weighted.
According to the lawsuit, Pearson bolstered her authority by claiming her previous newsletter business, The Newset, was generating $40 million a year.
Wait, 40 million?
Yeah, 40 million. And she allegedly told these investors she was personally worth $200 million.
Oh my gosh. If you're an investor sitting across the table, that combination is intoxicating.
It really is. You have the ultimate celebrity megaphone to acquire customers for free, paired with a seasoned business executive who knows how to monetize an audience.
It almost feels too big to fail.
Which is how they justified the staggering deliverables promised in the pitch. The lawsuit points to a specific email from June 2022 where Pearson allegedly claimed Wondermind had added 150,000 subscribers in a single month.
A single month. That's insane growth.
Yeah, and they projected $5 million in advertising revenue for their very first year.
Plus, they claim to be locking down institutional partnerships with financial heavyweights like JP Morgan and Fidelity.
And the celebrity name-dropping didn't stop with Selena. They told the investors they were securing cover stories with Tim Cook, Drake, Elton John, and Megan Thee Stallion.
Just casually getting Drake and Tim Cook.
Right. I'm looking at the sources, and they actually had a slide in their pitch deck labeled potential future value. It boldly projected a future valuation of $4 billion.
That's billion.
Yeah, $4 billion. They divided the company into media, product, and production arms and projected over $1 billion for each.
I mean, it was a narrative built on exponential, friction-free growth.
But this is where I have to pause and look at the psychology of the investors. Because if someone promises me an interactive app, cover stories with Apple's CEO, and a multi-billion-dollar return, my first response is going to be, show me the app's source code.
Right, exactly. Show me the proof.
Show me the signed contracts for those interviews. How does a seasoned investment firm hand over $1.2 million without demanding to see the actual tangible product? It's like buying a front-row VIP ticket to the ultimate concert, only to arrive and find out it's a hologram show.
That is a perfect analogy.
Yeah.
And that phenomenon is the defining characteristic of the celebrity-backed consumer brand model.
How does that actually work in their heads, though?
Well, in these hyper-competitive funding rounds, investors suffer from massive fear of missing out. They aren't actually underwriting the tech or the product. They are underwriting the distribution channel.
So they're buying the audience.
Exactly. In this scenario, that channel was Selena Gomez's 400+ million followers. Her vulnerability regarding her own mental health gave this brand an authenticity that traditional marketing budgets just cannot buy.
So from the investor's perspective, if Selena Gomez calls Drake, he picks up.
Right. Therefore, the claim that he will be on the cover doesn't seem like a lie. It seems like an inevitability. The investors believe the built-in audience was so vast that the quality of the product itself was secondary. The scale was guaranteed.
So they were essentially buying VIP access to an audience, assuming the products would just naturally follow. But the danger of building a $4 billion valuation entirely on the perceived magic of a celebrity and the supposed genius of a co-founder is that it's a house of cards.
Yeah, if either of those pillars cracks, the whole thing comes down. And if we connect this to the bigger picture, the higher the pedestal, the harder the fall.
And that's not even the wildest part. Later in the episode, we'll talk about a shocking twist with a disappearing bank account that nobody saw coming.
Oh, you do not want to miss that.
If you're loving these Hollywood twists, make sure you're subscribed. We've got even crazier stories ahead. But let's get back into the timeline.
Right, so the structural integrity of that house of cards was finally tested in the fall of 2025. This is when the glittering narrative collapsed.
And it didn't fall quietly behind closed boardroom doors. It played out in the national media.
Yeah, it started with a massive investigative piece by Forbes in August of 2025. Forbes took a magnifying glass to Daniela Pearson's track record.
Oh, right. Remember those massive numbers she used to establish her business credibility during the Series A pitch? The $40 million a year in revenue. The $200 million personal net worth.
Well, Forbes investigated her previous business, The New Set, and reported that she had allegedly exaggerated both her readership numbers and the company's valuation by a significant margin.
Oh, wow. You can imagine the chilling effect that had on the Wondermind investor pool. In venture capital, trust is the fundamental currency.
Absolutely. If the co-CEO allegedly inflated the metrics of her previous venture to secure institutional funding for Wondermind, every single metric she provided to Wondermind's investors suddenly becomes suspect.
Like, were the 150,000 new subscribers real? Were JP Morgan and Fidelity actually on board?
Right. And the panic was already setting in, but the real fatal blow landed a month later. In September 2025, The Cut published a brutal, deep dive investigation into Wondermind's internal operations.
That article was everywhere.
It was. They interviewed a dozen current and former employees, and the picture they painted was completely at odds with the polished mental wellness image the company projected.
What did they find?
According to the lawsuit, which cites this article as a key piece of evidence, Mandy Teefee, So, Selena's mother and the company's CEO allegedly struggled with severe, long-running substance abuse issues.
That is so sad to hear.
It is. The complaint details shocking allegations of erratic behavior, hallucinatory outbursts in the office, and claims that she was sometimes heavily intoxicated during work hours.
It is a profoundly tragic detail on a human level,
Right.
but from a legal and fiduciary standpoint, it directly contradicts the fundamental assurances given to the investors.
Completely. They were told their capital was being managed by a stable, capable executive team. Instead, the operational reality was allegedly chaotic.
And when the investors read these articles and demanded an explanation from Tiffy, the structural chaos deepened. Her response to the investors was explosive.
What did she say?
To defend herself, she essentially threw her co-founder under the bus. She informed the investors that Daniela Pearson was no longer with the company. In fact, Pearson had been ousted back in January 2023.
Wait, 2023, but the articles came out in 2025.
Exactly. And Tiffy didn't stop there. She claimed to the investors that Pearson had been fired because she misappropriated company funds to finance a lavish personal lifestyle.
Oh my gosh.
The legal complaint specifically alleges that Pearson used investor money to pay for a New York City apartment that cost $60,000 a month.
$60,000 a month for rent. That is unreal.
It is. Now, we have to pause here and state very clearly, for the record, that Daniela Pearson vehemently denies these allegations. She released a public statement stating she welcomes the opportunity to present formal financial records that establish the truth, and she completely denies ever using investor funds for personal expenses.
Right, and while these remain contested allegations in a civil suit, the timeline is what matters to the investor's case here. Think about the sequence of events.
Yeah, it's wild.
The seasoned co-CEO, who was supposed to be the business engine of the company, was allegedly fired under a cloud of financial impropriety in early 2023. Yet the investors only found out about it 2.5 years later after reading a magazine article.
Imagine finding out the company you invested your savings into hasn't built a single product in 3 years, and you only find out by reading a magazine article over your morning coffee. Why didn't the founders say anything?
That is the big question, and it immediately begs another question. Where was Selena Gomez in all of this? She was the chief impact officer. She was supposed to be intimately involved.
Right.
Well, that is the final revelation from the cut piece that forms the backbone of the lawsuit against Gomez. The reporting revealed that Gomez had actively distanced herself from Wondermind's operations for years.
Really? Why?
The reason given was a deeply rooted, undisclosed family dispute with her mother, Mandy Tiffy.
So the core premise of the investment, that Selena Gomez would be acting as the head of marketing, leveraging her massive audience to build a brand, was allegedly a mirage from the very beginning.
Yeah, the lawsuit argues that because of this pre-existing familial friction, Gomez never had any real intention of fulfilling her role.
Which means the 150,000 subscribers were allegedly fabricated. The Tim Cook and Drake covers were phantoms. The groundbreaking app was never coded.
Exactly. This raises an important question, though. What exactly were the founders telling the investors for those 3 years?
Right, like how did the company keep them in the dark for that long?
The legal complaint argues that the executives were actively engaging in a practice known as lulling.
Okay, I want to focus on this concept of lulling because it sounds gentle, but in a legal context, it's highly manipulative. It's like a magician utilizing misdirection. You keep the audience looking at the shiny object in your right hand so they don't notice what your left hand is doing.
That is a perfect mechanical analogy. In securities fraud, lulling occurs when a company's officers provide false reassurances, fabricated progress reports, or misleading updates specifically designed to keep investors placated.
So it's very intentional.
Yes, the legal definition hinges on intent. The goal of lulling isn't just to buy time, it is to prevent the investors from realizing a fraud has occurred, thereby delaying them from demanding their money back, liquidating their shares, or filing a lawsuit until it's too late.
And the examples of lulling detailed in this complaint are incredibly brazen. The most shocking anecdote in the sources happens in March 2025.
Set the scene for us.
Okay, so this is 6 months before the Forbes and the Cut articles break the whole thing wide open. An investor named Andrew Resnick emails Mandy Tiffy. He is essentially begging for a routine business update because the investors have been totally ghosted.
Now we have to contextualize what is allegedly happening inside Wondermind at that exact moment in March 2025.
This is bad.
It was a disaster. According to the investigative reporting, the company is in a state of total financial calamity. They are missing payroll, their relationships with external vendors are collapsing due to unpaid invoices, and they are in the process of essentially firing their entire remaining staff.
Yet, knowing all of that, Tiffy allegedly types up an email to Resnick claiming the exact opposite. She writes that the company just took a, quote, brief pause from fundraising so they could focus on a huge summer launch for a new app featuring AI and a social community platform.
Oh my goodness.
She claims they are being aggressively courted by a massive player in the media space.
And the cherry on top, she tells the investor she is currently taking meetings to propose Wondermind as the official mental fitness partner of the NBA.
The NBA. It is an alternate reality. Pitching a partnership with the National Basketball Association, while the company literally lacks the funds to pay its own employees, is the textbook definition of lulling.
Yeah, it really is.
It is projecting a hologram of aggressive growth and lucrative partnerships while the foundation is actively burning down.
Stay tuned and hit that subscribe button so you don't miss what's coming next, because this is where the legal hammer drops. Because lulling only works as long as the investors don't look behind the curtain.
And once the cut article drops in September 2025, the curtain is ripped away.
Exactly. The investors finally realized the scope of the alleged deception. By November 2025, they stop asking nicely. They formally issue a rescission notice. Now, a rescission notice is a powerful legal maneuver. It essentially says, the contract we signed was based on fraudulent premises, therefore the contract is void, return our $1.2 million immediately.
And the way the founders handle this rescission notice is arguably what escalated this from a business dispute into a full-blown federal lawsuit.
What did they do?
Well, instead of having their lawyers send a formal response, Tiffy allegedly emails the investors directly. She tells them there is no need to sue because Wondermind has an escrow account already set up specifically to return their funds.
Okay, an escrow account is a secure third-party holding account. Suggesting the money is sitting safely in escrow is a way to immediately de-escalate investor panic.
Right. So the investors say, great, send us the wire details for the escrow account. And then absolute silence. Tiffy allegedly ghosts them.
Wow. Just vanishes.
Yeah, weeks turn into months. The investors are continually asking for proof that this escrow account actually exists. Finally, in April 2026, almost half a year after the initial demand, Tiffy surfaces with a complete deflection.
What's the deflection?
She tells the investors, that would be a question for Selena's legal team. I'll connect you once they respond.
Oh, wow.
Yeah.
And according to the federal complaint, Selena Gomez's legal team never reaches out.
Nope.
The investors conclude there was no escrow account. The money was simply gone. Left with no other recourse, the investment entities filed the 48-page federal lawsuit in Delaware in August 2026.
Which brings us to the actual legal mechanics of the lawsuit. We've talked about the narrative, but how exactly do you prosecute this? Because they aren't just suing for bad business management, they are claiming systemic fraud.
Right. The plaintiffs are pursuing multiple causes of action. The heaviest hammer they are swinging is securities fraud under Rule 10b-5 of the Securities Exchange Act.
Let's translate that for the listener.
Wow.
Rule 10b-5 is essentially the SEC's primary weapon against deceit. It makes it illegal to employ any device, scheme, or artifice to defraud someone in connection with the purchase or sale of a security. So, lying about your revenue, lying about your active CEO, lying about a non-existent escrow account. I mean, if proven, those are all 10b-5 violations.
Precisely. They are also suing for common law fraud and breach of contract. But it's not just about how the money was raised. A massive part of this lawsuit focuses on how the money was allegedly spent. The plaintiffs are heavily relying on Section 1.4 of the stock purchase agreement.
Right, because venture capital contracts have strict rules. Section 1.4 explicitly required Wondermind to use the investment proceeds strictly for legitimate business purposes, product development, marketing, paying engineers.
If the allegations hold true that Pearson used those funds to pay $60,000 a month for a luxury personal apartment in New York City, that is a direct material breach of Section 1.4.
Which is huge.
Yeah, and consequently, Pearson is facing specific individual legal charges of conversion and unjust enrichment.
Let's define those, because they sound similar but work differently. Conversion, in a legal sense, is like taking someone's car for a weekend test drive, but then painting it, changing the plates, and selling it for parts.
That's a great way to put it.
It's an unauthorized assumption of the right of ownership over someone else's property. You converted company money into personal money. And unjust enrichment is the consequence. You received a benefit, like a luxury apartment at the investor's expense under circumstances that make it unjust for you to keep it.
That is an excellent breakdown. The plaintiffs are demanding the court force Pearson to disgorge or pay back any funds she unjustly converted for personal use.
Okay, here's where it gets really interesting, or my analysis hits a wall. I'm looking at the timeline of bad behavior. Selena Gomez didn't write the March 2025 email lying about the NBA partnership.
Right. Her mom, Mandy Teefee, did.
And Selena didn't pitch the inflated $40 million revenue numbers. Daniela Pearson did. The core accusation against Selena is that she essentially walked away due to family drama and did absolutely nothing.
Yeah, that's the claim.
So why is Selena personally being sued for fraud? How do the investors justify naming her as a defendant for simply being absent?
It is the most critical question of the case, and the investors are bridging that gap using a legal doctrine called control person liability.
How does that work?
Think of it like the captain of a commercial ship. Even if the captain is asleep in their cabin when the ship hits a reef, they are still legally liable for the crash because their name is on the registry, and they had the ultimate authority and duty to steer the vessel.
Ah, that makes perfect sense. Because Gomez wasn't just a passive influencer hired for a one-off commercial shoot. She was heavily embedded in the corporate structure. She was a formal co-founder.
Yes, and according to the documents, she owned roughly 16% of the entire company.
That is substantial equity.
It is. The lawsuit emphasizes that she also signed a specific consulting agreement that legally obligated her to perform certain duties for the company. The plaintiff's argument is that Gomez weaponized her institutional credibility. She allowed her name, her face, and her deeply personal mental health journey to be the primary lure to secure $1.2 million from these investors, knowing full well she had a fractured relationship with the CEO and allegedly possessing no intention of fulfilling her contractual obligations.
So the legal theory is that her silence wasn't just passive neglect. It was an active misrepresentation. By letting the company use her as the ultimate distribution channel while quietly refusing to distribute anything, she sold the illusion, took her 16% equity, and vanished.
Exactly. It tests the boundaries of what a celebrity owes an investor when they lend their name to a pitch deck.
So, to summarize the core tragedy of this deep dive, we have a startup that was built on a genuinely noble, culturally relevant goal, making mental health resources accessible to everyone.
Which is admirable.
It is. But behind the glossy Instagram posts and the visionary pitch decks, it allegedly dissolved into a $1.2 million black hole, defined by deep-seated family feuds, fabricated subscriber numbers, ghosted emails, and broken promises.
And this case serves as a harsh reality check for the influencer economy. For the last decade, Silicon Valley and venture capital have operated on the assumption that a famous face on a cap table is a golden ticket to a billion-dollar valuation.
Right.
But this lawsuit starkly proves that attention does not equal execution. Having 500 million followers cannot help you code a functional digital app.
Yeah, definitely not.
An Instagram audience cannot balance a financial ledger, and celebrity cannot fix toxic executive-level dysfunction. A famous face is merely a marketing tool. It does not guarantee a functional, legally compliant business.
We do want to remind you, as we wrap up this analysis, that everything we've discussed today regarding the complaint are currently allegations in a civil lawsuit. The defendants, Selena Gomez, Mandy Teefee, and Daniela Pearson, have not officially proven otherwise in court. And as we noted, Pearson has publicly and strongly denied the specific claims of financial impropriety against her.
Right, the legal process will ultimately determine the facts.
Exactly. But it is a fascinating cautionary tale. And it leaves you with a final thought to really mull over, especially if you ever find yourself looking at an investment opportunity.
Oh, for sure.
If a global superstar lends their name, their face, and their millions of followers to a pitch deck, but never actually intends to do the grueling, unglamorous work of running a startup,
Yeah.
does the moral and legal blame lie entirely with the star who sold the shiny illusion? Or does it lie equally with the seasoned professional investors who eagerly bought the hype without ever demanding to look under the hood?
That is the multi-million-dollar question.
It really is. You've been listening to Starscope Report, where Jordan and Jamie uncover the stories shaping Hollywood, music, and pop culture. Thanks for tuning in, and don't forget to subscribe for more stories that keep the stars shining.